Chelsea Community Church. We are a lay-led, non-denominational community welcoming people of all faiths or uncertain faith. It's with great pleasure that Chelsea Community Church presents in person and on Zoom the first of what we hope will be an ongoing series of presentations of interest to our Chelsea neighbors. And at the coffee hour, if you think of some subject you would like us to present, let me know. If you haven't already, be sure you all sign the register and back. And that way we'll keep you informed of the next event. And you've had our literature. And Bernard Prudenti has graciously provided exquisite refreshments. That's a new word I just added, from Le Pain Quotidien, so you know it's exquisite. And those are in the rectory next door following the service. And please enter through the front door of the rectory. And Bernard has also sent some wonderful literature and for you to take with you. Needless to say, it's a great pleasure to present Britt Berner. Her bio is extensive. Hello. And there's a copy over with their literature in the rectory, so make sure to take that. And that's it. So please, thank you so much again, and join me, welcome Britt Berner.
Thank you. So let me just be clear, Lynn, what time do you want me to speak until? Because, you know, I'm a lawyer. We could be here all night.
Are you doing a Q&A afterwards?
Yes.
We have the church until 8:30, the rectory. So
okay.
No rush.
I'm going to plan on about 45 minutes because
okay.
I could really bore you. I mean, I promise I could. So I'll plan on 45 minutes. I set a timer for that. So,
is asking questions.
Yep. So I'm gonna go through. I'll set the timer, and then I'm here for questions. The timer is just for me to get through, the main part of the presentation, because I've done it where I've taken questions throughout, but the problem is I'm usually going to get to those answers. So let's do the 45 minutes, and then I'm here free for all. Don't worry about time. So I'm Britt Berner. You can read my bio if you choose to, but some things I do want you to know about me, because I think it's important for you to know why you should listen to what I have to say today, is what I do. So Berner Prudenti Law, formerly Berner Law Group, although we became Berner Prudenti over this past summer, is a law firm focusing only on trusts and estates, elder law, and I have a lawyer other than myself that does real estate transactions. It's a law firm that's been around with different names for over 28 years. It was started by my mother. She is my law partner, along with our new partner, Gail Prudenti. And we have 4 offices, so I built and run our Manhattan office, which is over at Herald Square, and then we're also out on Long Island. They tend to man those offices along with the other 39 members of our team, lawyers and non-lawyers. And this is what we do. And ever since the firm started, we've found that the most important thing is not just to provide competent and compassionate legal services, but most importantly, to educate our communities. And, I live on the east side, I have to admit, but not too far from here. And we consider Manhattan and this part of Manhattan our community. And so the purpose of why I'm here today is not to give you legal advice. It's not to become your lawyer. It's to teach you about these issues. And hopefully you will leave here today with 1 or 2 new pieces of information that will help you or someone maybe that you help care for in your own estate planning. If you want more information, our website is a great resource for free information. We have a lot of short articles and also webinars. So me doing this, but sitting at a desk on different topics. So please feel free to look there. All that being said, that got in my first disclaimer, which is none of this is meant to be legal advice. My second disclaimer is that I'm going to be talking about very New York specific issues here. So some of these issues may be very similar in other states, but most of them will differ in other states. So everything I'm going to talk about here are for New York residents, and that's what you are, so it should work out quite well. So estate planning. When we talk about estate planning, I boil it down to three main topics. Probably came from the fact that my mom was raising us as she was coming up with these topics, and I've kept them up. It's PTA, right? PTA, probate, taxes, asset protection. When we're talking about estate planning, those are the main topics. I'm going to start there because I really want to get into that. I usually start with talking about healthcare proxy and power of attorney, and I am going to touch upon that, but I'm going to do that last. I'm going to go out of order today. So probate. Probate is the process of your will going through the court so that assets that are in your sole name with no beneficiary can pass along to your intended beneficiaries. So I said a lot in that one sentence. So probate is the process of assets that are in your sole name with no beneficiary. So let's stop right there. Sole name, meaning you're the only person whose name is on that. So whether it's that you own your co-op and the shares are in only your name, or you have a checking account, regardless of the amount of it, that is in only your name, you have an account that has no beneficiaries. So if you take someone who has a checking account, an IRA, and a co-op, right? Three pretty common assets. If that checking account is in just their name, and then the IRA might have a designated beneficiary on it, and the co-op shares are in just that person's name, then when the will goes through probate, it's only worried about the checking account and the co-op, because that IRA goes to the named beneficiary. So even if your will says, I give my beneficiary to my best friend, if that beneficiary designation with the institution, the bank that holds that IRA, says something different, that is what will control. That is the controlling factor there. They will ignore what the will says because the will is only controlling those assets in your sole name with no beneficiary. So what is probate? Probate is the process of making sure that that's a valid will, right? Anyone could scribble your name on something and say, oh, this was Britt's will. But there needs to be a court process, according to the law, to identify that that is actually my will, that it was actually signed by me, that it was actually my wishes, that it was my last will and testament. There were no future wills done that just weren't presented yet to the court, that it was an original document. It can't be a photocopy or a scanned copy. I had a very long back and forth with the gentleman because he kept saying, I emailed you the original. And I said, you can't email me an original. It doesn't work that way. And so a lot of people now use the term wet ink. I want the wet ink copy, not a copy of a copy, or a copy of the original. So the probate process is supposed to safeguard you and your beneficiaries to make sure that no fraud or duress or any of that is being perpetrated. So it has a process to it. Now, the most common misconception is people come in and they say, well, I don't need anything because I have a really good will, so I'm going to avoid probate. Now, you all should know from what I just taught you that that makes no sense, right? Because good will, bad will, wills need probate. If there's assets in your sole name with no beneficiary, we go back to that same phrase. So the process of probate requires first that the original will with a petition, and in the end the petition is a form, but of course because it's the courts it's incredibly difficult to fill out. But the will and the petition get submitted to the court saying, perhaps it would be, usually it's by the person who's nominated as the executor, that says, I have been nominated in this will as executor, and I'm presenting this will to the court to be admitted for probate. Now, I'm going to fast forward. The end of probate, once it's all said and done, if it all goes as planned, is that the will is admitted to probate, the executor is officially appointed by the court, because someone might say that person is, stole or is inappropriate, has a felony, something like that, can't be executor. And then that executor gets what's called letters testamentary. So a lot of times people say to me, I went to the bank and I tried to get my mom's bank account and they said I need a letter from the lawyer. You don't need a letter from the lawyer, you need letters testamentary, which are the final product of this probate process. So when the executor is putting this forward to the court at the outset, they're really just nominated, right? They are the nominated executor who is asking the court to officially appoint them. Realize that all of the assets that fall under that category of sole name with no beneficiary are frozen at this point, right? If you have an apartment, a co-op here in New York City, it's probably been sealed unless there's someone else who lives there and has a legal right to be there. Why? Because if you're saying that all of the contents of my apartment go to you because that's what the will says, but you have a different will that says something different, the probate process is going to figure out which one of you really gets that stuff. So the co-op doesn't want it on their back that they gave the stuff to the wrong person. So everything's frozen out. And the purpose is also to notify your legal next of kin that your will is being probated. So that is where it can get quite messy, right? So if I die and my will goes to probate and I say that I'm leaving my entire estate to the church, everything, 100% to the church, that's who's getting everything. My legal next of kin still have to receive notification of probate, regardless of the fact that they're not supposed to get anything. It probably goes back to many years ago. I say many, I mean hundreds of years ago, when the idea was you'd be crazy if you were leaving anything to anyone other than your direct family members. So it was an assumption that there was something had gone wrong and the family member should be notified. But now, another misconception, people come in and they say, no, don't worry. My estate's really easy. I have no family. That is an alarm bell for me. No family means, how am I going to find your legal next of kin, right? Because I have to find them, and we all have them, right? You might not know who they are. They might be a fourth cousin 9 times removed or some crazy distant relative, but they're there somewhere. And I think Lynn was saying, she's heard me speak about this before, and still to this day, my craziest story was a gentleman. I didn't know him while he was alive. I would have avoided probate if I did. But his friends came to me. He died. They were 50-50 beneficiaries and co-executors. And they came and they said, okay, here's his original will. Like, how do I get my money? Let's get this going. So we said, okay, well, we have to file for probate because he had one big account and it had no beneficiaries on it. I said, okay, so we just have to notify his legal next of kin. They looked at us like we were crazy, right? They're just friends. And I said, well, was he married? No. Did he have children? No. He was in his 90s, so it was clear his parents were deceased. Did he have siblings? No, he was an only child. Okay, so now we're looking at like a first cousin level, right? We're hoping they exist somewhere. And they're like, he was our friend. All we know about him was that his one parent, I forget which, but one parent was born in Egypt, the other was born in France, and they met during the war. They didn't know which war or where. They met during the war and then came to the United States together. So we really didn't know who these people were going to be. So in order to satisfy the probate process with the court, we had to hire an international genealogist. Very cool job. I kind of wish I had done it because it's very fun to dig into these things. International genealogist that is not paid a small amount of money to dig into his family history and records and any information we had to try and satisfy the court that we could find these individuals. Or at the very least, we had to keep going back to court, and finally the court was satisfied, okay, you've looked enough. And do you ever see in the back of the newspaper, there's those little square things and they say death notices? That's what they are, right? That's someone who's trying to probate a will, who can't find the next of kin, and finally the court says, okay, just put it in these 2 newspapers and publish in those newspapers, which, by the way, is not cheap. That's why there are very few words. Publish in those newspapers, and then we'll satisfy that you've put the people on notice and the church can get the money. Now just think about what that might cost, right? We have a genealogist, we have lawyers, we have all these things only to notify people who aren't getting anything and who you don't know who they are. I mean, when he was alive, he probably didn't know who they were, just so the church can get their money. So that's an example of why we avoid probate, right? We can't find your legal next of kin if we don't know who they are. Also, what if you do know who they are, but you're disinheriting them, right? Let's talk about the total opposite situation. I have 2 kids. I'm unmarried, I have 2 kids, son and a daughter. I'm leaving everything to my son and not to my daughter, and my will says something scathing like, for reasons only she knows. We see that a lot, people, it's very dramatic. Okay, well that's great. Your daughter's still getting a copy of that will and an opportunity to come to court and contest it. Now, she probably does know exactly why she's not getting anything, but she's not getting anything. But what might she do? Well, she might come to court on the day that she's being offered to come to court for probate and give her brother a hard time so he pays her to go away. Because otherwise, there's 1404 depositions where the lawyer who drafted the will gets dragged in and it gets messy, and that's where it gets messy. So that's the second time we avoid probate, right? If we're disinheriting one of these people who we think is going to be pretty angry that they're being disinherited. And then there's a lot of other reasons, but I'll say the third main reason we avoid probate, and this happens a lot, especially with people who are rent controlled here in New York City, I find. I have clients who pay, they're rent controlled in New York City and this is their primary residence, but maybe, sometime in the 60s or 70s, they bought like a small little cabin up in Massachusetts and they're always like, it's not worth anything. Well, it doesn't matter. In order to transfer title of that after you die, we would have to probate here in New York because it was your primary residence, and then probate in Massachusetts because everywhere where you own dirt, you have to probate. So if you own property in multiple states, you probably also want to avoid probate. And then there's the normal reasons which some people care about, like it's slow. Certainly since COVID, it's backed up. It's not efficient. It makes your will a public record. You can all go down to Surrogates Court on Chambers Street and see Joan Rivers' will if you really want to. It's a public record. So a lot of people want to avoid probate for those different reasons. But that's the most important thing. So what I always tell people is, and again, this gets back to, I want you to have a few good takeaways. And one of the big takeaways is, if you're going to a lawyer to talk about this stuff, you should be giving them a list of your assets. First of all, if they don't ask you what your assets are, just run. Because think about it. If you came in and didn't tell me what your assets were, how would I know what's going to go through your will, what has a beneficiary designated, what to tell you to do? So one is, if you go see a lawyer to do your will, they should be asking you what your assets are. They should ask you how they're titled, right? Are they joint with someone? Do they have a beneficiary, or are they in your sole name? And then the plan that they give you and the documents they draft for you or discuss with you should be based on the answers to those questions. I wasn't going to take questions in the middle, but does anyone have a question on that stuff right now before we move forward? In the back, yeah. Oh, here, I'll do it.
This is so interesting. When you started speaking, you said everyone has to do probate, and then you went through and you told us 2 instances when it would, very difficult, and why people want to avoid it. Does everyone go through probate? That's number 1. That's the only question right now.
Yeah, so no, the next topic I'm going to talk about is how to avoid probate.
I think you're going to cover it on the next topic.
Okay.
How to avoid.
Okay, so we'll go, how to avoid. Okay, so yes?
If you have siblings, then it stops. It doesn't have to go to France.
Oh, sorry, yeah. So that's a good question. You stop at the level at which you find next of kin. So if you have a spouse and children, they both count. So if you have a spouse and children, we don't look any further. If you don't have a spouse and children, and then it goes to your parents, and your parents are living, we don't look further. Then if you have sisters, brothers, it stops there. It doesn't go further. Correct. Yeah. Then if you have 8 cousins, they all get notice. You have to find, yeah, at that level. Yep. Because the rule is that if you didn't have a will, New York State says who gets your assets, right? So if I don't have, I'm unmarried and I don't have children, so my parents are still living. So if I were to die without a will, naturally, the law would give 50% of my property to my mom and 50% to my dad. They are what's called my distributees. They are the people that would take if I had no documents. So that's who gets notice, the people that would get everything if you didn't have a will.
Can you repeat the question, Britt?
Just want to follow up on the sibling question. If I had, well, I'm not married without children. My parents are dead. So there is just one sibling sister living. She would take everything.
She would be the one that would get notice, and without a will, she would take it.
Oh, without a will.
Right. So,
Oh.
so without a will, the law says who gets your assets. So if you don't have a will, so probate needs a will, wills need probate. So if you don't have a will, there's a process called administration, and these assets go to your legal next of kin. Those people are what we call your distributees. And so in my case, for example, it's my parents. So they are my distributees. They would get my estate 50-50 if I didn't have a will. If I have a will, which I do, thank God, because that would be embarrassing, but I do have a will, and so even actually my will says everything goes to my sisters. So, but even though my will says everything goes to my sisters, my parents are the ones who are entitled to notice of the will when I die, because they would take if I didn't have the will. Is that clear? Yeah. So that's how it works. And that's why, right? Because the idea is, if you didn't have a will, these are the people that would get it. So since you have a will that says something different, we need to let those people know they're not getting it. That's the idea. And they have the opportunity to say, you know, your sister made you sign that document, or, you know, or if it, in a lot of circumstances, it's, well, they had diminished capacity and they didn't know what they were doing. And not that you can't sign a will with diminished capacity, but things like that. So then how to avoid probate. So you know 2 of the answers already, right? If you have a beneficiary on a document, it avoids probate. If you have a joint owner, it avoids probate, right? We already said, because probate is for assets in your sole name with no beneficiary. So add a joint owner or add a beneficiary and we're out of probate. Then on some assets, you can't do that. So let me give an example. That person who maybe is rent controlled here in Manhattan and has that small little cottage in Massachusetts, and they might have a joint owner on their bank account, and they might have a retirement account with a beneficiary on it. They might even have a brokerage account, which is transfer on death to a beneficiary, right? It might all be dealt with, but that place in Massachusetts, I can't put a beneficiary on a house. So that's where we talk about trusts. I said to a client today, and I say this to clients a lot of people think trusts are only for the Rockefellers, right? They think, well, if you have a trust, you must be a gazillionaire. And trusts are not for everyone. But it's not always the dollar amount. Listen, obviously, if you don't have a lot of assets, it doesn't make sense to put it into a trust. But the real question is, what would happen when you died with that property? Because that's what matters. So the purpose of the trust might be, maybe it's only a $20,000 cottage up in Massachusetts, but it's going to cost, you know, $5,000 to $10,000 or more just to probate the will in both places. And so it makes sense to create the trust to avoid that. So it's going to depend. I have a lot of clients who come to see me, and they live in the city, they're full-time here, they don't have another place, they've designated beneficiaries on all their accounts, we don't have any tax problems we have to worry about, and they do a very simple will just in case something comes into their estate, but really for the most part their estate is going to avoid probate because they have beneficiaries on everything and they don't need a trust. But then there's other people who have a much more complicated situation in terms of what assets they own, and then a trust is necessary. All a trust is, I think people get very scared of the word. All a trust means is it's a document that creates a legal entity. So your will just says, when I die, this is what should happen. The trust does that, but the difference is when you sign a trust, you create it now, and very often you put stuff into it now. So for example, if I create a trust, it might be a revocable trust where I am in charge of it, I control it, it's my social security number, it doesn't change anything with taxes, but I'm trying to avoid this probate problem. Excuse me. I'm on the tail end of a cold, but so so you have a trust, and the way you get things into it is you actually retitle your assets, right? So if you do have that property in Massachusetts that I'm making up, you would sign a deed saying Britt Berner gives her house to the Britt Berner Trust, with Britt Berner as trustee of that trust. And it's like this weird little thing where it's like going to a closing, but you're the only person there. So you like put one hat on and you give the property, and you put your other hat on and you sign to accept it. And in the end, you really didn't change anything. But now the deed says Britt Berner Trust. So when I die, there isn't an asset in my sole name that doesn't have a beneficiary that would require probate. You can do the same with bank accounts, brokerage accounts, not with retirement. So IRAs, 401ks, that money, that does not go into a trust. That just stays in your name because it has a beneficiary. You would never move it. But other assets you might. And obviously for those who don't have, they have their regular bank account, they have their IRA, they have their rental apartment, they probably won't ever create a trust. But again, depending on who your beneficiaries are, if you have a disabled beneficiary, like sometimes I have someone who has one child, their child's on government benefits, right? Maybe Medicaid or Social Security disability or social SSI, and we're worried about them losing their benefits if they get all this money. Well, we might want to make a trust, and I'm not going to get too deep into that because we could really be here all night. You might want to make a trust that says, when I die, everything's going to go to my child, but they're going to be protected with a supplemental needs trust because I don't want them to lose their government benefits. So there's a lot of different reasons that we do trusts, and I think a lot of people come in and say, well, I don't have $1 million, or I don't have $10 million, so I don't need a trust. And it really isn't the amount so much as it is these circumstances, right? Who are your beneficiaries? Do they need any kind of protection? Should we be providing that protection for them? Do you think, well, they're lucky to be getting anything and they'll figure out their own protection? That's a perfectly fine answer, but someone has to ask you the question, right? You need to know, and that's why I always stress for people when you're meeting with a lawyer, they should ask you what your assets are, and they should ask you what your goals are. Like, what are you here trying to do? Are you here trying to do the simplest thing possible right now, and if it costs your family a little more money after you die, you're okay with that? Again, perfectly fine answer, but then I can help you design a plan that does that. There's some people that say, listen, I know it's a heavy lift for someone to be executor, and I don't want to make life hard on them, so how can we make it easy? What can we do to make this easy? And then we put that plan together. So it really is going to be different for everybody in the room because, the people on this side of the room might have $500,000 in real estate, and the people on this side of the room might have $500,000 in cash, and the people in the back might have it all in an IRA. Those are going to be three very different plans because the same dollar amount, but how you hold the asset is very different based on what the asset is. Okay, so that is my probate. I think we've talked about probate. We've talked about how to avoid probate. We've talked about trusts. I did touch upon administration, so I just want to say if you don't have a will, there is this concept that the state gets your money. That is not necessarily true. If someone dies and they don't have a will, then their next of kin, and there's an order of priority, can bring an administration proceeding with the court. It looks very similar to probate, but there's just not a will document. And then your legal next of kin receive that estate at the end. Now, if they can't find someone, sure, money might go into unclaimed funds because they can't locate the individual. But for the most part, it's not just that your money goes to the estate. A lot of people will come in, they say, my mom's gonna die and she doesn't have capacity anymore and she doesn't have a will and I'm her only child and I don't want everything to go to the state. That's not gonna happen. So I think that's a big, scary thing looming out there for people. Yeah.
I have a sister-in-law, and my brother's dead. And would she be next of kin through marriage?
That was a great question. Through marriage is not legal next of kin. It's blood. So sister-in-laws get nothing unless your will says, I give this to my sister-in-law. Some people will say in their will, I give this to my brother, but if my brother's deceased, I give it to my sister-in-law. Some people say, I give this to my brother per stirpes, which means down the bloodline. So your brother's children would get that share if he's deceased. But it will never default to the sister-in-law. Yeah, oh, you want to go?
Oh, yes. So I own a co-op. So I would have to put the co-op in a trust for my son?
Yeah, so yes or no. So this is the deal with co-ops. Most co-ops these days will allow transfer of ownership to trusts. That being said, there are some that don't, either just because the board doesn't want you to, or because I know we were talking about Penn South, and there's Mitchell Lamas, and there's other types of co-ops here in the city. But a regular, on the market, you could sell at fair value co-op, yes, we would approach the board, and we would say to the board, will you allow your shareholder to transfer the shares of the co-op into the trust? And very many do it. I actually have spoken to a group of real estate lawyers and pleaded with them that they let people do it, because what they don't, they're worried that it's going to put the co-op in a worse position, but really it doesn't. And the problem is someone dies, they die in their apartment, the apartment gets sealed either by the police because they died in the apartment, or the co-op doesn't let people in because, again, they don't have a legal owner of the apartment. It waits for probate. Maybe that takes 6 months. It's just sitting there. And meanwhile, that whole time, there's no one paying the maintenance. And there's no one paying the fees. So my argument to the co-ops is, wouldn't you rather it be in a trust so that immediately when the person dies, you have a trustee who's in charge of it, and you have a beneficiary who's going to get it, and you have someone on the hook? So they're slowly coming around. I think if we were giving this seminar 10 years ago, we'd probably be saying most co-ops don't allow it. I've now found it to be the switch, most do.
Thank you.
Yeah.
I have a quick second question. What are the pros and cons? I have difficulty finding someone who can be my executor. What are the pros and cons of having an attorney be an executor?
So I have served as executor in certain circumstances. I've only ever done it if someone asks me to. It's a hard job, so I will in certain circumstances do it, but it's not a job I'm chomping at the bit for. I do know there's a lot of attorneys who do it very regularly in their practice, so they really like it. I find it a little tedious. It's really hard. But that being said, I think, I don't know if there's any real cons. If you have a good lawyer and it's a good, honest person, which I would hope your lawyer is, I don't think there's any major cons. Fees usually go as such where, so let's say you had a best friend who was going to be your executor. Your best friend is, for the most part, entitled to commissions. So it's a calculation. It's not a straight percentage, but it's a calculation based on the size of the estate. And then very often that friend will hire a law firm to help them with the legal parts of the estate. When you have a lawyer as executor, it usually works the same way, but it's the same person getting both fees. So I don't know that I would file it in the category of downside. It's just something that your attorney is supposed to discuss with you so that you know it and you feel comfortable, and actually have you sign an affidavit saying that you've discussed it with them.
Just one quick question. Would it be possible, say, to make my son a co-executor with an attorney?
If the attorney allows it, then yes. Sometimes attorneys say that they don't want to act with a co-executor because I don't want my job to be, I can be more efficient on my own usually. But that being said, I'm sure there's some attorneys that don't feel that way. But again, I'm not really, pushing to be executors.
Thank you.
but
Quickly,
I do think, yeah, sure.
Sorry to interrupt. People on Zoom, if you have a question, please use the raise a hand, what's it called, emoji, and then we'll tell you to unmute. Thank you. No questions on Zoom?
We have one. In the top left.
Or if on Zoom, just wave your hand if you have a question.
Barbara's hand is raised.
Okay, unmute yourself, sir.
Yep.
I just wanted to quickly circle back to the co-op shares question, and maybe this is just because we're in New York City, but even where co-ops allow it, mine does, the cost is outrageous, I have to say. And so the question I have is, it sounds like you're strongly in favor of share transfer if it's allowed. I'm just saying it could easily cost $4,000 or $5,000 because the management companies and boards assess legal fees. So I'm just wondering if it's worth it at any cost for this simple question.
So, not at any cost. I have had multiple, I realize I'm looking at you, but you see me here, so I'm going to look here. I have had multiple people where they've said, I don't know if I'm going to live in this co-op forever. I might sell it. I don't have the money to pay for it. I don't want to spend, I have it, but I don't want to spend the money on it. And I've advised them, so then that's perfectly fine, then don't transfer it. The only thing is, if you are talking about older individuals who are likely to remain in, or maybe not remain there, but certainly not sell it before they die, and they're concerned about the transfer of assets to the next generation or to whomever their beneficiaries are, and not having these larger costs after death, then the cost of the transfer, while it might hurt on the inside to pay it, it can often actually be less than the cost to the estate for having to wait for the probate process. Because like I was saying, if you have $2,000 a month in maintenance, and it takes 6 months and very often more to get through probate, and that apartment is sealed during that time, that right there is $12,000 out the door for no one to live in an apartment. Now, some people say, well, they'll sell the apartment, they'll pay the $12,000 out of the sale, and they're very comfortable with that, in which case that's a perfectly fine plan. But if you believe that your beneficiary might want to stay in the apartment, or if you believe that, and again, remember I said, this is if there's no one else with legal rights to that apartment. So obviously, if you have someone who's on the proprietary lease with you, or someone who's living there with you, and the co-op recognizes that person as a legal tenant, then they'll be able to go into the apartment. But a lot of people don't want the after-death cost that is associated with holding on to the co-op and having to have it go through probate.
And also, just so I understand, you're also saying that that the apartment is sealed, so anything in that apartment also is untouchable by anybody until the probate process is completed, right?
Usually, yeah. So there's 2 ways the apartment gets sealed. One is by the NYPD, And that's if you die in the apartment. So I will tell you, if you die in an apartment and the you're removed from your body's removed from the apartment, the NYPD comes and they literally put a sticker seal on the door, and it can't be broken. And if somebody, let's say your original will's in the apartment, right? So now you're deceased, somebody has to get into the apartment to get the will. They have